wait a minute. So when the smoke clears, the law that prohibits commercials is valid or invalid? Not going to be any commercial advertising. Okay. On public issue ads, are those permitted or under your result? Permitted or not? Yes, permitted. Public. And political ads, they're permitted. Well, that's affirming it, isn't it? That's exactly what the Ninth Circuit did. It said no commercial type commercials, but the public issue and political ads must be permitted under the First Amendment. But that would be affirming. Okay. How many of you decided that all three prohibitions were constitutional? In other words, that the government can prohibit all kinds of commercials on public television? Keep your hands up. And how many of you had all three prohibitions declared unconstitutional? That is, public television must be allowed to air these commercials. Keep your hands up. Okay. Then who came up with some other result besides all, nothing, or the Ninth Circuit's solution? Benny. Wait a second. You affirmed on commercials. They can't have commercials. They can't have issue ads?
No, they can't.
Can't have issue ads. What's the rationale for that?
The rationale is as a result of citizens united, you can have social welfare organizations that are non-profit, bring unlimited amounts of money into political advertising. So you stimulate undermine the government's interest to educate people in public broadcasting and essentially like break down. I think in the Ninth Circuit's decision, they asked for the state elections, and I thought that this provided to continue the political ad.
Having gone through the Ninth Circuit argument, do you have a sense that that's the way that court will come out?
I don't think so. I kind of wrote it in a way that I really believed, and I sort of manipulated how the justices.
You manipulated the justices? Well, what other outcomes did you guys come up with? Because I counted there were at least 8 possible outcomes, permutations and combinations that are mathematically possible. Anybody have, Ruby?
I ruled that all three provisions are constitutional, but the exemption of nonprofits from the ban has another document that nonprofits are exempt.
Yeah, this law allows ads by nonprofit corporations of their products and services. That's unconstitutional? What makes, allowing them to do that, why is that unconstitutional?
I made the argument of like favoring for-profit speech or nonprofit speech.
Yeah, and then on the other 3, you decided that...
So both for-profit and nonprofit should be banned from having partnerships with that.
Okay, so at least it's consistent.
Yeah.
You don't end up with a system under which only nonprofits can advertise. Yeah, so no, it's a nothing situation that you end up with. Well, it's at least possible that the court could say that the political ads are permitted, that the government can't outlaw political ads under the First Amendment, but commercial ads would remain prohibited, and public issue ads would remain prohibited. That strikes me as implausible, to put it mildly, that if they're going to uphold any of these 3 as, or not uphold, but if they're going to say that any of these 3 is protected speech under the First Amendment, isn't the best candidate public issue ads? Actually not. Please. Now, how is is there any difference between what you can think of as a public issue ad and the advertisement in New York Times versus Sullivan? Heed the rising voices, seeking money for the civil rights movement. That was a paid advertisement in the Times. Is there any difference between that and whatever you can think of as a public issue ad? It seems to me that's the type of ad that might well be at issue when you're talking about banning public issue ads. Kind of hard to justify the government saying you can't air that kind of an ad. And what's the only basis for saying that all 3 types of commercials should be prohibited?
I know this is like a commercial part of that, but it's not to be the broadcast station. It's licensed as a public nonprofit organization. In order for it to be nonprofit or public, we cannot have an advertising that other broadcasting stations have. It's not really restricted speech. It's just basically giving broadcasting stations choices. Would you like to be a nonprofit or a for-profit? If you choose to be like a nonprofit broadcasting station and receive public money, then you should follow these rules. It's not really restricting speech per se. They still editorialize you have to like clear it. I'm writing this news app, like they can do whatever they want, just they can't have commercials. Yeah, that happens. And it's hard to like prevent public broadcasting stations from being nonprofit if they allow that. That was the issue.
Are all public television stations non-profit? I don't know. What we do know is that not all of them seek or accept federal money.
Right.
Namely, Minority Television Project doesn't take it.
Made the argument that he received like tax-deductible donations and he got license free.
Right. Yeah, that's important. The donations would otherwise be taxable if they were for-profit. You're probably right that they are all, in fact, non-profit. It doesn't make a difference whether they receive federal money.
Well, I guess if you receive federal money, that's usually an important argument that I agree with.
Yeah. Well, there are other permutations. That is that commercial-type commercials should be permitted, that the government can't outlaw them, but that the government can outlaw public issue and political ads. That's irrational. I mean, it's possible to cut up the pie that way, but it would make no sense at all. They could ban, the court could say that public issue ads are banned, but the other two are okay. That's totally irrational as well. The court could say that political ads are banned, but that commercial and public issue ads are okay. Maybe saying this is political speech, core First Amendment protected speech, the public issue ads and the political ads. That's, I guess, pretty much the way no, that's not. The political was banned. No, that's right. I confused myself. What's the most relevant precedent in this case, previously decided case? Nicole? Well, those are three different cases. Which is the most relevant? Yeah, I think that's right. It was in fact very close, right? Where the court held that the federal law that prohibited public broadcasters from airing editorials violated the First Amendment. How do you distinguish that case? I mean, given our common law method of decision making under stare decisis, the current court, even a generation later, is required to follow League of Women Voters unless it can be distinguished or overruled. So if you want to come out saying that this political or public issue advertising, if those prohibitions on that are constitutional, you have to distinguish League of Women Voters. Can you? Can you say, this case is different from League of Women Voters in this respect that justifies a different outcome? An editorial isn't an ad. I mean, the difference, the obvious difference, is we're talking about paid advertisements of three kinds, as opposed to editorials. And on the next level of generality, editorials are the speech of the broadcaster, what they think about the world, which on its face seems to deserve constitutional protection. Whereas with the ads, you're talking about paid advertisements, and the government is saying, through the statute and through the arguments of the court, that permitting any paid advertisement is different from editorials because it corrupts the public educational mission of the public station. You may or may not accept that argument, but it seems to me you can distinguish League of Women Voters. What about Citizens United? Is that important in the resolution of this case? Okay.
I use it a lot.
You use it a lot.
Not a lot, but I use it as a strong case against allowing political advertisements because I said that with the invention of super PACs that was motivated by the decision that they have politicians having issues have the buying power of almost corporations, which would just keep.
Yeah, so you're using your unhappiness with the outcome in Citizens United and the aftermath of Citizens United as you see it to bolster your argument that they ought to ignore Citizens United, right? Not follow it.
Not me, Kagan. Doesn't take
Oh, it's definitely Kagan. But you're the ventriloquist. And you got her saying these awful things about Citizens United. Yeah, they don't have to follow Citizens United. Weren't you persuaded by Judge Bea's distinction of Citizens United? It had nothing to do with broadcast. And the only relevance, only direct relevance, is this true? Is the only direct relevance of Citizens United that it seems to emphasize the preciousness in our system of political speech, so that a court might cite Citizens United in support of an argument that restrictions on political speech, even though they're paid ads, are constitutionally suspect. Yeah, I could do that. Whose speech is at stake in these cases, anyway? Is it the politician's speech? Is it the Planned Parenthood's, the nonprofit would-be, wannabe issue advertiser? Or is it General Motors and Budweiser, the commercial sponsors who want to put on ads? Is it the advertiser's speech, or is it the station's speech? Alex? Both?
Yeah, because obviously the political ads are banned because their speech is at stake, they can't air the ads. And then the opinion that the broadcasting station's programming, with certain programming pretty much at stake. Like if it was replaced by programming influenced by advertising.
I think even if the words spoken in ads are not the words of the station, they're produced by the advertiser, which is a main difference, another main difference between editorials and commercial. Even if all the words belong to the advertiser, originate with the advertiser, the publisher of those words is the station. So it's really, they clearly would have standing, I think, to complain that their First Amendment rights are being violated as well. To what extent is this case, with regard to commercials, a commercial speech case? Very few of you so far have based anything in your decision on the fact, isn't it a fact, that the commercial type commercials are pure commercial speech? A category of speech that we learned merits less than full First Amendment protection. Seems to me that ought to be confronted, that you've got, with regard to commercials, commercials, you've got a double-barreled disability built into that. It's commercial speech, which gets less First Amendment protection, and it's commercial broadcast speech, and broadcast speech all by itself seems to merit less constitutional protection. So that makes it an uphill battle to argue that commercials ought to be constitutionally protected. Sorry, full free and whole.
Like, I think it was somebody that said this, you mentioned, like, isn't a corporation telling you, like, that they, assert good or service is available? Like, isn't that a matter of public issue?
Yeah, well, the court has decided in the commercial speech cases that simply because it's commercial speech doesn't mean it can be banned, because it fills a societal need to inform consumers about what's available and so on. Yeah, so it merits some constitutional protection, but not as much as political speech, for example, or non-commercial speech. What we're talking about with these commercials, I think, is flat-out commercial speech. Buy my product. It's not issue ad. So, well, Nicole? Okay. Well, so how do the justices vote? Boy, this is hard, isn't it? Most of you, seemed like so far, most of you came out, regardless of the way the case was decided, with the conventional conservative-liberal split, a 5-4 conservative-liberal split, even though you came out differently on the thing. And I'm curious about what you thought the individual justices would do. League of Women Voters, the most relevant precedent, you can't look back to that and say which way the justices would go, because there's been 100% turnover on the court since 1984, I think it was, when League of Women Voters was decided. So you're writing on a clean slate, with one exception that one of you pointed out to me that I hadn't picked up on. Justice Alito argued that case for the government, for the FCC, when it was in the court, when he was in the Solicitor General's office. So he made the arguments for the FCC that the government should be able to prohibit editorials on public television. Does that mean that he would take that position in this case? Why not? He what? He disqualified himself? Recused himself? Recused himself because of a position he took 25 years ago, or whatever it was, when he's a government lawyer, not his personal crusade, he's simply doing his duty as a government employee, arguing the government's position. Now he has to recuse himself? Rehnquist never believed that. Rehnquist took his position as a government lawyer in many cases, never recused himself, even though he probably should have. I don't think Alito would recuse himself. I don't think he'd be required to. The court has its own ethical standards that they govern only them. And I don't think that he would necessarily make the same decision as a judge as the one he advocated as a lawyer on this issue. But as I said, League of Women Voters really doesn't help you identify the individual justices, Nicole. Yeah. He did say during the oral argument last year in the Fox television case, which is about indecency on broadcast radio and television, a subject that we will reach a week from today, he did say during that argument something to the effect that the broadcast these days is just a whisper of what's available in the media. It's a tiny little portion of information available to the public, and why do we even bother saying that it should be treated differently from any other media, indicating, I think, a hostility to Redline and Pacifica and so on, treating broadcast as less protected than other media. So maybe he follows Thomas, who has said basically the same thing in another of the indecency cases. But Thomas, when last year in the Fox television case, this is about Cher using dirty words and Janet Jackson's breast and so on, Thomas had the opportunity in that case to say the very basis for this government regulation, Pacifica, Red Line, he had said that in the previous Fox television case. Last year, he didn't say a word about it. He didn't write an opinion at all. Ginsburg did. And Ginsburg comes out and says, those were wrong when they were decided. They're even more wrong today. The technology is overtaking whatever validity those cases had. We should get rid of them. What does that tell you about how she would vote? Well, that introduces the unpleasant subject of intermediate scrutiny versus strict scrutiny, which has got to be totally boring to your readers of your report on the Supreme Court's decision. You start talking about intermediate scrutiny and strict scrutiny, and the readers of your publication doze off or put it away. What is this? But it's important doctrinally because it involves by what standard you judge the constitutionality of these restrictions. Well, if Ruth Ginsburg says Pacifica and Red Lion are wrong, we shouldn't follow them anymore, what's the consequence of that? Not that we therefore must allow commercials on public television, just that we judge that restriction by strict scrutiny because it's content-based rather than intermediate scrutiny. And I'm not at all sure that a court applying strict scrutiny might come out the same way as with intermediate scrutiny and say, yeah, these actually do survive, or don't survive. I don't think the court draws an important difference between compelling interest and substantial interest. And they always focus on narrow tailoring, and they can come out whichever way they want to. Okay?
Isn't one thing that you really have to wait here that Congress specifically made public broadcasting stations for a specific purpose being very different? Mm-hmm. Like, should that be considered? Like, we haven't really discussed that portion of the case, which I think totally frames the case differently. I mean, it's not just talking about Fox or something else. I mean,
right.
These stations were made for a specific purpose of being very independent.